Good afternoon, everyone. Let me open the session of the Committee Against Torture, number 1267. As you all know, we have consideration of the report from the United States, and today we're going to hear the replies of the States Party to the Convention. Just to brief you about the procedure, first we will listen to the States Party's delegation, and we will hear the responses to the questions of the committee put forward yesterday. And the delegation will have 90 minutes, 90, to reply to the questions. Then I will have to pass the floor back to the committee members, starting with two rapporteurs, and then with the committee members who will wish to take the floor. So, the floor is yours, Ambassador, and thanks again for joining us today here.
Thank you, Mr. Chair. Members of the committee, on behalf of the U.S. delegation, we thank you all for your important and thought-provoking questions. Particular thanks goes to Rapporteurs Mr. Bruni and Mr. Medvig. We look forward to having a useful dialogue and value your input on how we can make further progress. I note at the outset that a number of members of the committee have asked for extensive and detailed data. Our team has done its best overnight so that we can provide you with as much as we can. Other information was not readily available. To help the committee understand how we are structuring this response, I wanted to provide a bit of a roadmap. In order to address as many of your questions as possible in our allotted time, we have largely organized our presentation by agency. Following me, my Department of State colleagues will begin our response. General Gross will then speak on behalf of the Department of Defense, and I will follow General Gross. After that, colleagues from the Department of Justice, Department of Homeland Security, and the states of Rhode Island and Mississippi will answer additional questions. Assistant Secretary Tom Malinowski will then conclude this portion of our response. Please do not take the brevity of our responses as minimizing the importance of these issues. With that, I will turn it over to Acting Legal Advisor Mary McLeod to start our responses. Thank you.
Thank you, Mr. Ambassador. Mr. Bruni and Mr. Gaillet, you raised questions about non-refoulement and the use of diplomatic assurances. First, as a matter of fundamental policy and practice, the United States does not transfer any individual, whether located in U.S. territory or not, to a foreign country if it is more likely than not that the person would be tortured. This principle is woven thoroughly into U.S. policy and practice in a number of ways, including Section 1242 of the Foreign Affairs Policy and Restructuring Act, where it is specifically stated, and in Executive Order 13491, which required the formation of a special task force on transfer policy to study and evaluate the practices of transferring individuals to other nations in order to ensure consistency with all applicable laws and U.S. policies pertaining to treatment. The task force made a number of policy recommendations to ensure that persons are not transferred to face torture when the United States moves or facilitates the movement of a person from one country to another, or from U.S. custody to the custody of another country. The President accepted the report. If the United States determines, after taking into account all available information, that it is more likely than not that a person will be tortured, the United States will not make the transfer. The United States considers a range of factors in determining if it is more likely than not that a person will be tortured, and the issuance of diplomatic assurances and the reliability of those assurances is only one such factor. Other factors considered include any allegations by the person of prior or potential mistreatment by the receiving government, the receiving country's human rights record, and whether similarly situated persons have been tortured. There have been cases where the United States has declined to return individuals because the United States was not satisfied that even with assurances, the transfer would be consistent with its non-refoulement obligations, policies, or practices. For example, the United States has long maintained its position that it would not repatriate Uyghurs to China from Guantanamo due to our humane treatment policies. In some cases, we seek assurances as a prudential matter. not because they are necessary for the transfer to be consistent with the non-refoulement principle, but rather to reduce further any meaningful risk of mistreatment. Likewise, in the context of armed conflict, the U.S. practice has been to seek humane treatment assurances. To answer your specific question, Mr. Bruni, we have received humane treatment assurances from every country to which we have transferred a detainee from Guantanamo during this administration. Mr. Gaillet, you asked what corrective measures we would be able to apply if a country did not abide by its diplomatic assurances, in view of the fact that the transferred person would be in the hands of the receiving state. With respect to law of war detainees and in other contexts involving continued detention where appropriate, the United States requires assurances of private access on minimal notice for post-transfer monitoring by credible independent organizations or U.S. government officials. If that monitoring reveals mistreatment or other credible information of mistreatment comes to our attention, we may suspend future transfers. I'll now turn to your question, Mr. Bruni, pertaining to the United States understanding that mental pain or suffering refers to prolonged mental harm. When the United States was considering becoming a state party to the convention, there was some concern that the convention's definition could not satisfy the constitutional requirement of precision in defining criminal offenses with respect to mental pain and suffering. We conditioned our ratification upon an understanding that mental pain or suffering refers to prolonged mental harm to provide the requisite clarity and specificity for purposes of domestic law. With regard to your question, Ms. Belmire, related to the International Criminal Court, the United States has signed agreements with more than 100 states that apply to United States persons. In general, states concluding the agreements agree to surrender or transfer such persons to the International Criminal Court only with the consent of the state concerned. To date, there have not been any requests for such consent under these agreements. For its part, the United States is fully committed to investigating and prosecuting, where appropriate, acts that amount to war crimes, crimes against humanity, and genocide alleged to have been committed by its officials, employees, military personnel, or other nationals. The agreements contain language specifically underscoring this intention and reaffirming the importance of bringing to justice those who commit such crimes, and this would include any such crimes that are covered by the Convention. At this point, I'll turn to questions related to enhanced interrogation techniques. As ordered by President Obama, the former detention and interrogation program is over and will not be reinitiated. This is reflected in our laws. The Detainee Treatment Act of 2005 prohibits cruel, inhuman, or degrading treatment or punishment at all times and in all places, and CIA Director John Brennan has made clear that no agency, officer, or contractor will participate in any interrogation activity inconsistent with the Detainee Treatment Act or the Army Field Manual. My colleague, Brigadier General Gross, will speak more about the Army Field Manual shortly. President Obama's Executive Order 13491 also required the CIA to close as expeditiously as possible any detention facilities that it operated and prohibited it from operating any such detention facility in the future. The CIA is in full compliance with the requirements of that executive order and does not maintain detention facilities. At this point, I would like to turn this over to my colleague from the State Department, Catherine Amirfar.
Thank you. In the Legal Advisor's Office at the Department of State, it is a privilege to be here on behalf of the United States today, and I thank the committee for its thoughtful comments and questions. Messrs. Bruni and Modbig, I will address the questions you posed with respect to the geographic scope of the application of the Convention. So let me start by saying that torture is absolutely prohibited at all times, in all places, no matter what the circumstances. Likewise, cruel, inhuman, or degrading treatment or punishment is absolutely prohibited at all times and in all places. And these are legal prohibitions based on U.S. domestic law, treaties, and customary international law. For example, the prohibition against torture is customary international law binding on all nations everywhere at all times. Articles 2 and 16 of this convention require prevention of both torture and cruel, inhuman, or degrading treatment or punishment in territory under U.S. jurisdiction. Under the DTA, or the Detainee Treatment Act of 2005, takes it even further. No individual in the custody or under the physical control of the U.S. government, regardless of nationality or physical location, shall be subject to cruel, inhuman, or degrading treatment or punishment. Under the DTA, the prohibitions apply at all times and in all places, not just to territory under U.S. jurisdiction. In the context of armed conflict, the Geneva Conventions prohibit torture and cruel treatment as well. President Obama issued Executive Order 13491 to ensure humane treatment in compliance with the treaty obligations of the United States, including this convention and the Geneva Conventions. Any individual detained in any armed conflict who's in the custody or under the effective control of the United States or detained within a facility owned, operated, or controlled by the United States in all circumstances must be treated humanely and must not be tortured or subjected to cruel, inhuman, or degrading treatment or punishment. Taken together, these make clear that these prohibitions are categorical and unequivocal. They bind the United States and its officials at all times, everywhere. There exists the separate question under the Convention of the geographic reach of the Articles, specifically referring to territory under a state's jurisdiction. Since its last presentation, the United States has carefully reviewed the extent to which such obligations under the Convention apply beyond the sovereign territory of the state's parties. The United States understands that where the text of the Convention provides that obligations apply to a state party, quote, in any territory under its jurisdiction, end quote, such obligations extend to all places that the state party controls as a government authority. We believe this is the proper interpretation of the Convention. It's consistent with the position taken by both the U.S. executive branch during the ratification of the Convention and by the U.S. Senate in considering whether to provide advice and consent to ratify the Convention. This language clearly covers the sovereign territory of the United States. In addition, we believe that it covers other places the United States controls as a governmental authority. We've concluded the United States currently exercises such control at the U.S. Naval Station at Guantanamo Bay, Cuba, and overall proceedings conducted there, and with respect to U.S. registered ships and aircraft. I should note that with respect to the obligation in Article 16 to prevent cruel, inhuman, or degrading treatment or punishment, that provision also explicitly extends to territory under a state's jurisdiction. As this committee is aware, the United States submitted a reservation with respect to that provision to ensure that existing U.S. constitutional standards would satisfy U.S. obligations under that article. Let me be clear that this reservation to Article 16 does not introduce any limitation on the geographic applicability of that article. The obligations in Article 16 apply beyond the sovereign territory of the United States to any territory under its jurisdiction in line with the interpretation I have just outlined. Now, with respect to the application of the Convention at Guantanamo, in our last presentation to the committee, the United States stated that Article 15 of the Convention is a treaty obligation and that the United States had to abide by that obligation in the Combatant Status Review Tribunals, also known as the CSRTs, and the Administrative Review Boards, also known as ARBs, which were administrative procedures established to review the status of law of war detainees at Guantanamo Bay. CSRTs and ARBs are no longer conducted, but the United States reaffirms its obligation to abide by Article 15 in the periodic review board processes, which is a current discretionary administrative process for the review of law of war detainees at Guantanamo, as well as in the military commissions. In that regard, the Military Commissions Act of 2009 mandates, and I quote, "No statement obtained by the use of torture or cruel, inhuman, or degrading treatment shall be admissible in a military commission, except against a person accused of torture or such treatment as evidence that the statement was made." Implementing this exclusionary rule in the context of reviewing or prosecuting individuals detained in armed conflict complements and reinforces the prohibition on torture and the fair trial guarantees mandated by the law of armed conflict. With that, let me turn back to my colleague, Ms. McLeod, to address one further point.
Mr. Modvik, I now turn to your question about the applicability of the Convention during armed conflict. In terms of our international law obligations, during situations of armed conflict, the law of armed conflict is the lex specialis, and as such, is the controlling body of law with regard to the conduct of hostilities and the protection of war victims. Moreover, as the United States has already recognized, a time of war does not suspend the operation of the Convention Against Torture, which continues to apply, even when a state is engaged in armed conflict. Article 2.2 of the Convention specifically provides that neither a state of war nor a threat of war may be invoked as a justification for torture. In addition, the law of armed conflict and the Convention contain many provisions that complement one another and are in many respects mutually reinforcing. For example, the obligations to prevent torture and cruel, inhuman, or degrading treatment or punishment in the Convention remain applicable in times of armed conflict and are reinforced by complementary prohibitions in the law of armed conflict. Whether you are looking at human rights law or the law of armed conflict, the prohibition against torture and cruel treatment is categorical. There are no gaps. Although Article 14 of the Convention contemplates an enforceable right to fair and adequate compensation for victims of torture, it would be anomalous under the law of war to provide individuals detained as enemy belligerents with a judicially enforceable individual right to a claim for monetary compensation against the detaining power for alleged unlawful conduct. The Geneva Conventions contemplate that claims related to the treatment of POWs and protected persons are to be resolved on a state-to-state level, and war reparations claims have traditionally been, and as a matter of customary international law are, the subject of government-to-government negotiations as opposed to private lawsuits. In closing, there can be no question that the clear position of the United States is that torture and cruel, inhuman, and degrading treatment or punishment are legally prohibited everywhere and at all times. There can also be no question that these prohibitions continue to apply even when the United States is engaged in armed conflict. These prohibitions exist under domestic and international law, including human rights law and the law of armed conflict. The United States remains dedicated to enforcing these prohibitions to ensure that there are no gaps, that there are no loopholes, in order to fulfill a primary purpose of the Convention, to recognize the inherent dignity of persons and right to be free from torture and cruel, inhuman, and degrading treatment or punishment. And now let me give the floor to Brigadier General Richard Gross.
Thank you. Mr. Chairperson, distinguished members of the committee, I am Brigadier General Rich Gross, and I am here on behalf of the Department of Defense. I am honored to address the committee today regarding U.S. military operations and policy. At the outset, I would like to reaffirm the Department of Defense's commitment to the United States' clear position that torture and cruel, inhuman, or degrading treatment or punishment are categorically prohibited under domestic and international law everywhere at all times. Now, let me start by addressing the questions from Special Rapporteur Bruni about President Obama's commitment to close the detention facility at Guantanamo Bay and the current population there. As you noted, sir, President Obama has repeatedly reaffirmed his commitment to close the detention facility, and in his May 2013 speech at the National Defense University, he outlined a series of steps to reach that goal. Since then, 18 detainees have been transferred from Guantanamo. The vast majority of these transfers were a result of internal administrative review procedures established to ensure we detain only those who continue to represent a significant threat to the United States. The United States is currently holding 148 individuals at Guantanamo under law of war authority. Of those, 79 detainees are currently designated for transfer, subject to appropriate security and humane treatment measures. 33 detainees have been designated for potential prosecution, either in federal court or by military commission, and 36 detainees are designated for continued law of war detention and will be periodically reviewed. Now, Ms. Belmere, you ask about the periodic review of detainees. The Periodic Review Board, or PRB, process mandated by President Obama began in October of 2013. This process is a discretionary, administrative, interagency process intended to assist the executive branch in making informed decisions as to whether detainees held at Guantanamo Bay should remain in detention under the law of war. On November 5th, the United States completed the first repatriation of a detainee designated for transfer by the PRB. And Ms. Belmore, to address your questions regarding the legal status of detainees at Guantanamo, I would like to note that these detainees continue to be detained lawfully, both as a matter of international law and U.S. domestic policy. As a matter of international law, the United States is engaged in an armed conflict with al-Qaeda, the Taliban, and associated forces. As part of this conflict, the United States has captured and detained enemy belligerents and is permitted under the law of war to hold them until the end of hostilities. All U.S. military detention operations conducted in connection with armed conflict, including at Guantanamo Bay, are carried out in accordance with international humanitarian law, including Common Article 3 of the Geneva Conventions and all applicable international and domestic laws, including the Convention Against Torture. Now, Special Rapporteurs Bruni and Motvig, you ask about specific fair trial guarantees to Gitmo detainees, and in particular, Article 15 protections within the military commissions. All current military commission proceedings at Guantanamo incorporate fundamental procedural guarantees that meet or exceed the fair trial safeguards required by Common Article 3 to the Geneva Conventions and other applicable law. These fundamental procedural guarantees include the presumption of innocence, the right to counsel, including specially trained counsel in capital cases, the right to discovery of evidence, and the right to appeal conviction, ultimately to the U.S. federal courts. In compliance with Article 15, the Military Commissions Act expressly forbids the introduction of a statement obtained by the use of torture or by cruel, inhuman, or degrading treatment, except against a person accused of torture or such treatment as evidence that the statement was made. Now, Mr. Motvig, regarding your question about the classification of certain information in military commissions, we must balance the need to comply with U.S. law and regulations regarding the protection of classified national security information with the United States' strong interest in ensuring the detainees meaningful access to counsel, including the ability of detainee counsel to access relevant classified information. The United States respects the critical role of detainee counsel in these proceedings and will continue to make every reasonable effort to ensure that counsel can communicate effectively and meaningfully with their clients. Now, many of you ask about the U.S. Army Field Manual on interrogations. And Mr. Zhang, sir, you asked for a copy of that manual. The manual is publicly available in its entirety online, and we've provided you with the link at your chairs. The interrogation techniques or guidelines in the Army Field Manual are consistent with U.S. domestic and international legal obligations, and the techniques are binding on the U.S. military as well as all federal government agencies, including intelligence agencies and the High Value Interrogation Group, or HIG. This applies to all individuals in U.S. custody or under U.S. effective control in any armed conflict. The manual explicitly prohibits threats, coercions, and physical abuse. Nothing in the Army Field Manual, to include Appendix M, authorizes or condones the use of sleep manipulation or sensory deprivation. For example, Mr. Bruni, you mentioned the language in Appendix M that states that the use of separation must not preclude the detainee getting 4 hours of continuous sleep every 24 hours, and questioned whether that would be adequate over a 30-day period. First, this standard must, of course, be applied consistently with all applicable legal, regulatory, and policy principles and guidelines, which provide that all prisoners and detainees, regardless of status, will be treated humanely. The 4-hour standard is not a daily limit, but rather a minimum standard. It is certainly not intended to mandate, for example, 30 days of separation with only 4 hours of sleep per day, nor would it allow 40 continuous hours of interrogation with only 4 hours of sleep on either end. As the manual states, in attempting to determine if a contemplated technique or approach should be considered prohibited, Consider whether, if the proposed technique were used by the enemy against one of your fellow soldiers, you would believe your soldier had been abused. And I personally use that particular phrase with folks in determining whether the technique they want to use is lawful. Now, Mr. Bruni, you ask about the registration of detainees. In every armed conflict, the United States has taken seriously its obligations under domestic and international law to ensure humane treatment of detainees. Under standard U.S. military procedures, each individual detained by U.S. forces for more than a temporary period is assigned an internment serial number, or ISN, which begins a formal process of oversight and record keeping. Every ISN is reported to the International Committee of the Red Cross, or ICRC, and the ICRC is given access to these individuals as well as to all internment locations. Every person who is released from detention is afforded an exit interview with the ICRC, wherein he or she is given the opportunity to raise any concerns or allegations of mistreatment. In addition, by executive order, all departments and agencies must provide the ICRC access to detainees in a manner consistent with Department of Defense regulations and practice. Mr. Modvig, you also ask about independent medical examinations and issues of medical ethics with regard to detainees. Detainees at Guantanamo are provided with high-quality medical care, comparable to that which our own service personnel receive while serving there. U.S. practice is consistent with principle number 2 of the non-binding principles of medical ethics. DoD physicians and healthcare personnel charged with providing care to detainees take that responsibility very seriously. Military physicians, psychologists, and other healthcare personnel are held to the highest standards of ethical care and at no time have been released of their ethical obligations. Permitting non-military medical examinations of detainees would undermine the effectiveness of healthcare delivery. In addition, the availability of outside medical examinations could encourage detainees to refuse the care of the Guantanamo medical staff in an attempt to attain such examinations and to get alternate treatment plans. Nevertheless, the Department of Defense has allowed independent non-military medical examinations of Guantanamo detainees on a limited case-by-case basis where circumstances warrant such an exception. Now, Mr. Bruni and Mr. Modvig, you ask about the enteral feeding of detainees at Guantanamo. Enteral feeding is used as a last resort, where necessary, to address significant health issues caused by malnutrition and/or dehydration. It is the policy of the United States to support the preservation of life by appropriate clinical means in a humane manner and in accordance with all applicable laws. The Department of Defense has established clinically appropriate procedures to address the medical care and treatment of individual detainees experiencing the adverse health effects of clinically significant weight loss. These procedures are administered in accordance with all applicable domestic and international law pertaining to humane treatment. My colleague from the Department of Justice will address Mr. Bruni's specific question about the ongoing litigation over these procedures. Now, Mr. Modvig, you asked for additional information regarding investigations and prosecutions for the alleged mistreatment of detainees. The U.S. military is and always has been required to investigate every credible allegation of mistreatment by U.S. forces in order to determine the facts, including identifying those responsible for any violation of law, policy, or procedures, no matter how senior that individual may be. The U.S. military has a robust judicial system and other administrative mechanisms designed to ensure that personnel adhere to the law and policy associated with military operations and detention. Pursuant to these mechanisms, the Department has conducted thousands of investigations since 2001 and prosecuted or disciplined hundreds of service members for mistreatment of detainees and other misconduct. For example, more than 70 investigations in Afghanistan resulted in full courts-martial. Close to 200 resulted in either non-judicial punishment or adverse administrative action, and many more were investigated and resulted in action at a lower level. Now, Mr. Modvig and Ms. Pradhan-Mala, you ask about measures to prevent sexual violence and assault in the military. Eliminating sexual assault from the military is one of our absolute top priorities. Through continuous assessment and improvement, we seek to improve our response and prevention programs, and it is one of the Secretary's highest priorities. Within the past couple of years, the Department has implemented monumental reform efforts in this area. The Secretary of Defense has directed a range of initiatives designed to strengthen new and existing programs addressing areas including commander accountability, oversight, investigative quality, pretrial investigations, command climate, victim advocacy, and victim support and safety. In addition to physical and mental health care for survivors who remain on active duty, survivors who transition out of military service are offered physical and mental health care through the Department of Veterans Affairs, the VA, the Veterans Health Administration Mental Health Services, Veterans Centers, and other resources. The VA provides free, confidential treatment for mental and physical health conditions related to sexual trauma, regardless of service-connected disability ratings. At this time, I will now return the floor to my colleague, the Ambassador.
Thank you, General. Members of the committee, I will address questions raised by Mr. Bruni and Mr. Modvig regarding the potential visit to the United States by Special Rapporteur on Torture and Other Cruel, Inhuman, and Degrading Treatment or Punishment, Juan Mendez. As a starting point, we want to be clear that the United States fully supports Special Rapporteur Mendez and his mandate. We appreciate his diligence in examining situations involving torture and cruel, inhuman, or degrading treatment or punishment around the world. Accordingly, we are open to a country visit to the United States by Special Rapporteur Mendez. To the question regarding a visit to detention facilities in the United States, we hereby confirm our willingness to facilitate such a visit. We have communicated the same to Mr. Mendez. To the question regarding Guantanamo specifically, as we have made clear to Mr. Mendez, we would welcome his visit under the terms previously conveyed to him. Security concerns dictate limitations on detainees' ability to communicate with others during wartime. Therefore, Mr. Mendez would have the same access as is granted to members of our own Congress and civil society. Private access to detainees is only granted, however, first to the International Committee on the Red Cross as contemplated by the Geneva Conventions, and two, to Detainee Council. Both Detainee Council and ICRC have special roles and responsibilities. Both, furthermore, are bound by duties of confidentiality. I also wanted to thank Mr. Bruni for mentioning the UN Voluntary Fund for Victims of Torture. As many of you know, the United States has had a long-standing commitment to the fund and to its mission. It is a mission which has important links to the goals and purposes of this committee. And now I will turn it over to Robin Jacobson, Associate Deputy Attorney General for the Department of Justice.
Thank you, Ambassador. Distinguished members of the committee, my name is Robin Jacobson, and I am an Associate Deputy Attorney General at the U.S. Department of Justice. I am honored to appear here today on this subject of such importance to the Department of Justice, and to have the opportunity to respond to your questions about individual redress under Article 14, the availability of habeas corpus to persons detained by the United States, certain medical issues pertaining to detainees, registration of detainees, watch lists, and rehabilitation of torture victims. To begin with Article 14, outside the context of the law of armed conflict, U.S. law provides a wide range of civil remedies for seeking redress in cases of torture. These include injunctions, compensatory damages, punitive damages, and declaratory relief. In addition, the U.S. Congress has authorized the federal government to bring civil actions to enjoin acts or patterns of conduct that violate constitutional rights, including those that would amount to torture. At the federal level, the principal avenues of individual redress are administrative tort claims and civil litigation. Common law tort actions for assault, battery, wrongful death, civil actions for violations of federally protected civil rights, suits based on federal constitutional rights. On the state level, all of our states provide for civil tort suits to be brought against state officials, and many permit damages for violations of state constitutional rights. With respect to prisoners in particular, Mr. Modvi, Ms. Pradamala, and Mr. Chairperson, you all expressed concern about the Prison Litigation Reform Act, and in particular the requirement that there be an underlying physical injury in order to qualify for compensation for emotional distress. The Act was broadened in 2013 to allow a showing of the commission of a sexual act as an alternative to physical injury to establish eligibility for compensation for emotional distress. The Act does, as you noted, require inmates to pursue and exhaust administrative remedies before bringing suit in federal court. That requirement provides correctional agencies both an opportunity and an encouragement to resolve the issues themselves. If and when a case must go to court, it then ensures that there will be a full record available on which to evaluate those claims. Importantly, the Act does not preclude incarcerated persons from seeking other legally available relief, apart from compensatory damages, for mental or emotional injury from unconstitutional conditions of confinement. Now, apart from the limitations imposed by that Act, prisoners in federal or state prisons claiming that they have been tortured may seek redress against state and local officials in a civil suit for violations of fundamental rights pursuant to 42 U.S. Code Section 1983, a federal statute. They may obtain monetary damages and may seek injunctions to require prison officials to correct conditions that violate the Constitution. Mr. Moravig, you asked questions about the reach of the right to habeas corpus for persons detained by the United States. Under the U.S. Constitution, and absent exceptional circumstances, all persons in the United States have the right to seek habeas corpus review, challenging the lawfulness of their detention. With respect to the reach of the constitutional right to habeas corpus outside the sovereign territory of the United States, our Supreme Court has identified factors to be considered, including the citizenship and status of the detainee, the adequacy of the process through which that status determination was made, the nature of the apprehension and of the sites of apprehension as well as the detention, and the practical obstacles that are inherent in resolving a habeas claim in those circumstances. The right to bring habeas proceedings has been held by the courts to reach extraterritorially to the detainees held by the military at Guantanamo, as well as to U.S. citizens detained by U.S. military authorities overseas in Iraq. The U.S. respects the fundamental importance of the role of detainees' counsel in all such proceedings and makes efforts to ensure that counsel can represent detainees in an effective and meaningful manner. For habeas cases challenging military detention at Guantanamo, detainees can request a court-appointed lawyer to serve free of charge. And in addition, hundreds of private attorneys have volunteered their experience and their time to provide that legal representation. Mr. Bruni, General Gross has already addressed many of the questions you asked about enteral feeding, but you also asked for an update on the status of litigation involving Guantanamo detainees, and I'm happy to provide that. As you noted, in early October, a federal district judge in Washington, D.C., conducted an evidentiary hearing addressing a legal challenge brought by a detainee, Abu Diab, to the enteral feeding policies at Guantanamo. That followed a lengthy evidentiary discovery period, and it included expert testimony submitted by the detainee's counsel. Just last week, the court rejected the detainee's challenge and denied his motion to enjoin the enteral feeding protocols. The court held that the record established that Joint Task Force Guantanamo had provided that detainee and the detainees subject to these protocols with appropriate medical care, was not deliberately indifferent to his medical needs, and had not deliberately caused him pain and suffering. The detainee has formally indicated that he will appeal that ruling. In accordance with the judge's order in that case, classified videotapes that relate to those feedings have been produced to Mr. Diab's attorneys and submitted to the court under seal. On October 3rd, the court ordered also that the videos be publicly disclosed with certain information redacted. Last week, the court granted the government's request to stay that order until December 2nd, pending a decision by the United States whether to appeal. And just yesterday, a different federal judge denied another request by a different detainee to enjoin the Guantanamo enteral feeding policy as to him, finding no deliberate indifference to the detainee's medical needs, and citing the reasoning by the federal judge in the Diab case, which we just talked about. Mr. Motvig, you also asked about independent medical examinations, and General Gross has addressed that issue with respect to Guantanamo detainees, and he explained the rationale for the limitations in that policy. The Federal Bureau of Prisons is charged by statute with providing medical care for inmates, and it does so with its own staff and with officers from the U.S. Public Health Service. The physicians who treat inmates follow all relevant medical and ethical requirements and take those very seriously. And outside medical examinations and treatment are arranged by the Bureau of Prisons under contract when medically indicated. Mr. Bruni, you asked about registration for detainees, and General Gross has addressed that issue with respect to detainees held by the military. Although there is no unified national policy governing registry of all persons in detention in the United States, relevant federal, state, and local authorities maintain appropriate records on persons they detain. The U.S. and state constitutions, as well as other laws, provide comprehensive safeguards to ensure that those in detention are protected and provided due process. In the criminal context, all persons are booked when taken into custody, and such bookings, which generally include name, description, charges, and emergency contact information, are public information. Moreover, the requirement for a prompt public court appearance provides further protection. Mr. Delmar, you asked about watch listing, which we understood to be a reference to the U.S. no-fly list. The U.S. government is actively reviewing and revising the existing redress procedures regarding the no-fly list. In so doing, we are attempting to increase transparency for certain individuals denied boarding who believe they're on the no-fly list and have submitted inquiries to the Department of Homeland Security. And we're doing so consistent with the protection of national and transportation security and classified and other sensitive information. Finally, Mr. Motvig, we appreciate your recognition of the efforts of the United States to date to help rehabilitate victims of torture. The Torture Victims Relief Act, originally enacted in 1998, authorizes funding for a number of programs that provide rehabilitation services, including funding for the Department of Health and Human Services and the U.S. Agency for International Development to support treatment centers and programs in and outside the U.S., respectively. The Department of Health and Human Services Agency for Children and Families provides funding to 30 torture treatment centers located in 19 of our 50 states. It funds research for survivors of torture and related trauma. And the USAID Victims of Torture Fund provides funding for rehabilitation services for torture victims located outside the United States and helps fund research on torture treatment through Johns Hopkins University. Now my colleague, Mr. Bidkauer, will address some of your additional questions. Thank you.
Good afternoon. Once again, my name is David Bidkauer, and I am a Deputy Assistant Attorney General from the Justice Department's Criminal Division. Mr. Motvig and Mr. Zhang, you both asked about training in lawful interrogation methods and internal reporting requirements and internal reporting mechanisms as well. We believe that the training described in our periodic report has been successful in preventing mistreatment during interrogation. The FBI continually trains its personnel on adherence to the Constitution and laws of the United States, including the prohibition against torture, and to promote the humane treatment of any detainee with whom it is involved. This is the case whether the detainee is in FBI custody or the custody of another agency or country. With regard to internal reporting mechanisms, the FBI has in place a range of internal controls and oversight mechanisms that are intended to prevent, detect, and address any violations of law or policy. I can also offer the following additional information from the Bureau of Prisons. At the Federal Bureau of Prisons, allegations of mistreatment of inmates are investigated by the BOP's Office of Internal Affairs and/or the Department of Justice's Office of Inspector General. All staff members are subject to discipline, including suspensions, demotions, and removals for mistreatment of inmates. For cases closed during the past year, there were 26 subjects with a sustained physical abuse allegation. If warranted, staff members can be referred for criminal prosecution as well, as in an example that I will cite in a moment. Mr. Bruni, you asked about interrogation techniques employed by the High Value Detainee Interrogation Group, or HIG. The HIG was established to improve our ability to interrogate the most dangerous terrorists by bringing together personnel from the FBI, the CIA, and the Department of Defense. HIG personnel are bound to comply with the legal and policy limitations of the HIG itself, as well as of their home agencies. Thus, interrogations conducted or supported by the HIG, like all interrogations conducted by personnel from its constituent agencies, are conducted consistent with the provisions of Executive Order 13491 and with United States domestic and international law, including the Convention Against Torture. Mr. Bruni, you also asked what measures existed to respond to the use of enhanced interrogation techniques if they are still practiced. Enhanced interrogation techniques are no longer practiced, and any United States personnel who employ torture or cruel, inhuman, or degrading treatment or punishment concerning a detainee would be violating the law. You also asked about the status of the Law Enforcement Torture Prevention Act. As we have previously noted, the Convention does not require state parties to enact a crime specifically labeled torture, but rather to ensure that the underlying conduct encompassing torture is criminalized. Under United States law, that conduct is prohibited by various statutes. For example, torture may be encompassed by statutes prohibiting torture under that term, as in the prosecution of Chucky Taylor, which we described yesterday. Or it may be encompassed by statutes prohibiting, for example, the violation of civil rights. As one example, in 2006, 4 correctional officers at the Federal Bureau of Prisons participated in the abuse of an inmate who was thrown to the floor and restrained while one of the officers repeatedly stomped on his back and shoulders. 4 officers were prosecuted and convicted in federal court for violating the inmate's civil rights and sentenced to prison. Because we believe the relevant conduct is already covered, the administration is not actively considering adopting new federal legislation prohibiting torture within the United States. Mr. Bruni, you also asked whether, although U.S. law prohibits the commission of torture by United States nationals everywhere in the world, an American official could escape liability by effectively delegating the commission of torture to officials of a foreign government. The answer to that question is no. Just as federal law prohibits actions taken by United States officials personally, so would it apply to actions directed or willfully caused by those officials, even if those actions were actually carried out by others. You also requested examples of public officials prosecuted for offenses that would constitute cruel, inhuman, or degrading treatment or punishment, as prohibited in the Detainee Treatment Act of 2005. Following are 2 examples from the civilian justice system of prosecutions under federal criminal law, and my colleague General Gross has already discussed actions taken by the military justice system. In June 2003, David Pissarro, a CIA contractor stationed at a United States Army base in Afghanistan, participated in taking an Afghan man named Abdul Wali into custody and detaining him at the base. Pissarro then interrogated Wali in connection with rocket attacks on the base and brutally beat him, after which Wali died. The CIA Inspector General referred the case for prosecution. Pissarro was then indicted by the Department of Justice for committing assault. In August 2006, he was convicted following a jury trial. In November 2008, Don Ayala, a Department of Defense contractor in Afghanistan, participated in capturing and detaining an Afghan civilian named Abdul Salam. Salam had doused another American contractor, Ms. Paula Lloyd, with a flammable liquid and set her on fire, causing her death. After learning what happened to Ms. Lloyd, Ayala approached Salam, who was still being detained, and shot him to death. In February 2009, Ayala was convicted in federal court of manslaughter. Both Mr. Modvig and the chairperson asked for further information regarding Mr. Durham's review regarding detainees alleged to have been mistreated while in U.S. custody subsequent to the September 11th attacks. Mr. Durham and his team reviewed the treatment of 101 such detainee cases. In so doing, he drew upon information provided by the CIA Inspector General, a report from the International Committee of the Red Cross regarding the treatment of high-value detainees formerly in CIA custody, the Department of Justice's report on legal guidance related to enhanced interrogation techniques, and other sources. After reviewing a substantial volume of information, Mr. Durham recommended the opening of 2 full criminal investigations, and Attorney General Holder accepted that recommendation. After investigation, the Department ultimately determined not to initiate prosecution of those cases. That decision was made based on the same principles that federal prosecutors apply in all determinations of whether to initiate a prosecution. Specifically, Mr. Durham's review concluded that the admissible evidence would not be sufficient to obtain and sustain convictions beyond a reasonable doubt. Because the cases did not result in prosecutions, I cannot publicly describe with specificity the investigative methods employed by Mr. Durham or the identities of any witnesses his team may have interviewed. Overall, however, the investigations involved interviews of approximately 96 witnesses and the examination of physical and documentary evidence. In short, Mr. Durham had access to and reviewed a broad array of information relating to allegations of mistreatment. In addition, prior to Mr. Durham's review, career prosecutors at the Department of Justice reviewed certain cases involving alleged detainee abuse. These reviews led to charges in several cases, including the 2 cases I previously discussed. The Department determined not to initiate federal prosecution in other cases for reasons consistent with the same principles of federal prosecution that I discussed before. With respect to individuals who provided legal advice regarding the permissibility of enhanced interrogation techniques, a 2010 review conducted by a senior career Department of Justice official concluded that 2 senior Justice Department lawyers who gave advice in 2002 and 2003 regarding the application of the torture statute and the use of specific interrogation techniques had made errors and had exercised poor judgment, but that they had not intentionally or recklessly provided incorrect advice or acted in bad faith. Mr. Modvig, you also requested an update into the investigation by Mr. Durham of the destruction by CIA personnel of videotapes of detainee interrogations. In November 2010, the Department announced that after an exhaustive investigation into the matter, Mr. Durham had concluded that he would not pursue criminal charges. The committee asked a number of questions regarding conditions of confinement in prison, including the use of restricted housing. As the committee is aware, the vast majority of imprisoned persons in the United States are held in state facilities. My colleagues will therefore address some of these questions. I will address questions that particularly regard federal facilities. Mr. Bruni, you asked about the psychological effects of the use of restricted housing on prisoners. We thank you for allowing us the opportunity to clarify and express to the committee that restrictions on prisoner housing in the United States are not taken for the purpose of inflicting psychological harm, but rather to ensure the security of the prison environment. We are, however, committed to preventing any abuses with regard to detention conditions and to ensuring the safety of vulnerable inmates. The Bureau of Prisons has undertaken a comprehensive and independent assessment of the use of restricted housing in the federal system and is looking forward to sharing further information on this subject once the study is released in the coming months. Mr. Bruni, you asked whether it could constitute mental torture for prisoners to spend a period of years between being sentenced to death and having that sentence carried out due to their pursuit of appeals or other procedural mechanisms to challenge their convictions or sentences. Although we cannot comment on any particular pending litigation, we do not believe as a general matter that delays that result from a convicted prisoner's decision to take advantage of the heightened procedural safeguards mandated by the Constitution and laws of the United States constitute a form of mental torture. Mr. Chairperson, in response to your question, the President has directed the Department of Justice to conduct a review of how the death penalty is applied in the United States. The Department is taking a look at this. We have no additional update at this time. Finally, Mr. Bruni, you asked about efforts to reduce the federal prison population. These efforts have been a priority for the Attorney General and have taken a number of different forms, many of which are reflective of the recommendations in the congressional report that you cited. For example, as part of the Smart on Crime initiative announced last year, the Department has modified its charging policies to ensure that mandatory minimum sentences are reserved for the most serious criminals. In 2014, with the support of the Department, the United States Sentencing Commission adopted amendments to lower guideline penalties for all drug offenders. In addition, the Department is pursuing alternatives to incarceration for low-level, nonviolent crimes, including the use of diversion programs that do not require incarceration. Just 2 weeks ago, in fact, the Attorney General visited one such program at the federal courthouse in Brooklyn, New York. In September 2014, the Attorney General announced that the federal prison population had dropped by approximately 4,800 inmates in the past year. This is the first time the federal inmate population has fallen over the course of a 12-month period since 1980. I will now turn to my colleague Jennifer Dynas from the Department of Justice Civil Rights Division.
Mr. Chairperson and distinguished members of the committee, my name is Jennifer Dynas, and I'm an acting senior counsel in the Justice Department Civil Rights Division. The Civil Rights Division works to uphold the civil and constitutional rights of all who live in the United States. Mr. Modvig, you asked about the federal government's response to recent events in Ferguson, Missouri. The Department of Justice is working across the nation to ensure that the criminal justice system is fair, constitutional, and free of bias. Among the federal government's efforts in Ferguson, Missouri are an ongoing and active criminal investigation into the fatal shooting of Michael Brown, which is separate from the local investigation and is looking at whether there were federal civil rights violations. There is also an active and ongoing civil investigation into the Ferguson Police Department that is focused on 4 key areas: the Ferguson Police Department's use of force, including deadly force, stops, searches, and arrests, discriminatory policing, and treatment of detainees inside Ferguson City Jail by Ferguson police officers. The Justice Department's Community-Oriented Policing Services Office, often called COPS, has launched a voluntary collaborative reform initiative with the St. Louis County Police Department, which will include an open, independent, and objective assessment of key operational areas of the police department. The findings and any recommendations will be provided in a public report. Additionally, the police department requested that COPS conduct an after-action report on the police department's response to the protests following Mr. Brown's shooting. That investigation is underway. Finally, President Obama ordered the U.S. government to review federal programs that provide military equipment to local jurisdictions, including whether and which such material should be provided to local law enforcement, whether local police units are receiving proper treatment for the equipment they receive, and whether that equipment is being effectively tracked. Ms. Belmere, in response to your question about for an update on the Chicago Police Department and John Burge, several individuals who were convicted after allegedly being subjected to improper tactics by the Chicago Police Department were ultimately exonerated of the underlying crimes. However, a federal civil rights investigation did not develop sufficient evidence to prove beyond a reasonable doubt that prosecutable constitutional violations occurred. Ms. Belmere and Mr. Gaye, you asked about the use of tasers. The Civil Rights Division recognizes that the vast majority of law enforcement officers work tirelessly to protect the rights of the communities they serve. But when officers commit unconstitutional violations or violate individuals' rights under federal law, the division can and does prosecute individual officers criminally and has successfully prosecuted many cases involving tasers. In a recent case, the division obtained a guilty plea from a Pennsylvania police officer in 2013 for an assault against a victim involving the use of a taser, all while the victim was handcuffed and not posing a threat. And in the civil context, the division intervened in a civil action alleging excessive force through the inappropriate use of tasers by the Franklin County Sheriff's Office in Columbus, Ohio, which resulted in a court-enforceable agreement. I will address a number of questions regarding prison conditions. Mr. Bruni and Mr. Modvig, you both asked about extreme heat in prisons, including in Louisiana and Texas. The Civil Rights Division has authority under the Civil Rights of Institutionalized Persons Act to investigate and remedy unconstitutional conditions of confinement imposed by state and local governments, pursuant to a pattern or practice of civil rights violations. The Department of Justice filed a statement of interest in a civil case by inmates challenging the constitutionality of extreme heat conditions at the Louisiana State Penitentiary at Angola. The court issued an order in favor of the plaintiffs and the case was appealed. The Justice Department filed an amicus brief in support of the plaintiffs, arguing that the district court's findings under an Eighth Amendment violation and the corresponding injunctive relief were properly made and entered. The department also received information about extreme heat conditions in Texas prisons from the University of Texas Human Rights Clinic earlier this year, but we are unable to comment on the pending litigation in Texas or the merits of those cases. Mr. Chairperson and Mr. Modvig, you asked about juveniles. The Justice Department is committing to protecting the rights of youth in juvenile detention and commitment systems. We often obtain relief that is designed to reform juvenile detention systems and that affects large numbers of juveniles. For example, we have agreements concerning 7 facilities for juveniles in Puerto Rico, 7 juvenile facilities in Ohio, and 14 facilities in Los Angeles County, California. Mr. Modvig, in response to your request for statistics, according to the Department's Bureau of Justice Statistics, approximately 7,400 youth ages 16 through 17 were in adult prisons and jails in 2011. And in 2011 through 2012, an estimated 4.7% of these youth in prisons and jails experienced sexual victimization. Rates of sexual victimization were higher in state juvenile facilities and state contract facilities. In 2012, an estimated 9.5% of all adjudicated youth held in state or privately run facilities experienced sexual victimization. Excluding youth held in locally or privately operated facilities, the rate of sexual victimization declined from 12.6% in 2008 through 2009 to 9.9% in 2012. This is largely due to a drop in reported staff sexual misconduct. With regard to the question about life sentences for juveniles, the U.S. Supreme Court has held that sentences of life without parole violate the Eighth Amendment's prohibition on cruel and unusual punishment when applied to juvenile offenders for non-homicide crimes committed as a juvenile and cannot be made mandatory for juvenile offenders, even those who have committed murder. We are working with members of Congress to refine legislation drafted to address the Supreme Court's decisions on these issues. Mr. Bruni, Mr. Taguchi, and Mr. Modvig, you also asked about solitary confinement. The U.S. Constitution prohibits the use of seclusion in a manner that constitutes cruel and unusual punishment. The Civil Rights Division currently has matters involving allegations of misuse of solitary confinement in 20 states and U.S. territories, and has issued findings or reached settlements in some of those matters. For example, in May of 2014, the Division reached an agreement with the State of Ohio and private plaintiffs which will dramatically reduce and eventually eliminate its use of seclusion on young people in its custody. The agreement also ensures youth in juvenile facilities will receive individualized mental health treatment to prevent and address the conditions and behaviors that led to the seclusion. Mr. Bruni, you asked about sexual violence in detention. The United States is taking extensive action to prevent sexual violence in its detention centers. As you know, the Prison Rape Elimination Act, or PREA, aims to prevent, detect, and respond to sexual abuse in confinement facilities at the federal, state, and local levels. States that do not comply with the Justice Department standards issued under PREA face certain reductions in their Justice Department funding. The Civil Rights Division has conducted 3 civil pattern of practice investigations that focus exclusively on the sexual abuse of prisoners. And as an example of the Division's work in the criminal realm, earlier this month, a former captain at a detention center in Albuquerque, New Mexico, pleaded guilty to federal charges related to sexual assaults of women inmates in his custody. This is but a sample of the Civil Rights Division's work. I will now turn to Director Wall of Rhode Island to address a number of your questions from the state perspective. Thank you.
Mr. Chairperson and distinguished members of the committee, my name is A.T. Wall. I am Director of the Department of Corrections for the state of Rhode Island, one of the 50 states that together comprise the United States of America. I serve as the Chief Executive Officer of an agency that is responsible for Rhode Island's adult correctional operations, including both jails and prisons. I joined the profession 38 years ago at the line level, and I've dedicated my career to the compelling challenges of our field. We in corrections know that we hold great power over those who are subject to our authority. We have a corresponding duty to exercise it fairly, thoughtfully, humanely, and with respect for their human rights. State correctional systems accomplish our mission within the overall framework of federalism, whereby authority is allocated between the national government and the states. Federal and state laws function together in a manner consistent with the provisions of the United States Constitution. I'm honored to appear before this committee and to respond to the questions that you have raised. Mr. Chairperson, Mr. Modvig, and Ms. Pradhan Mala, in response to your questions about solitary confinement, recent efforts to achieve reforms in this area have addressed the process of determining whether to place someone in such a status. the degree of isolation, the condition under which the inmate lives in this setting, the opportunities to earn removal from the status, and ways to reintegrate into the general population. My perspective, of course, is that of our state. In Rhode Island, we make efforts to ensure that inmates in administrative segregation are in fact not completely isolated. For instance, they have non-contact visits, the ability to communicate with inmates in neighboring cells, outside exercise 3 days per week for 1 hour minimum, access to education and reading materials, radios, mail privileges, legal assistance, meetings with staff upon request, out-of-cell access to clergy, and monthly telephone calls to family. Above and beyond, in some states, individual case reviews have been taking place of everybody in this status and have led to significant declines in the use of supermax cells without compromising safety and security. Mr. Bruni and Mr. Modvig, in response to your questions about the Prison Rape Elimination Act, sexual assault, and LGBTI issues in prisons. We correctional officials are developing policies and practices to comply with the Prison Rape Elimination Act standards in order to protect inmates against sexual coercion by staff or other inmates. It bears noting that staff sexual misconduct with inmates is a crime in every single state. Consent is not a defense. PREA mandates independent audits to determine compliance, and that process has already begun. The audits cover a wide variety of subjects, including training of staff, background checks, education of inmates about their rights, investigative protocols, individualized assessments of risk for victimization or predatory behavior, responses from medical and mental health personnel, cooperation with law enforcement authorities on criminal charges and victim services. They are comprehensive. Rhode Island is among the overwhelming majority of the states that are working to actively meet those standards. The standards include a focus on the vulnerability of LGBTI offenders to sexual abuse. States have adopted practices designed to respect the dignity of these persons, make individualized housing and program placement for them, and protect them from harassment and victimization. It is done through specialized training for custody and clinical staff and many other ways as well. Mr. Bruni, in response to your questions about overcrowding, advocates and the Department of Justice have filed numerous lawsuits targeting overcrowding as a violation of the Eighth Amendment's prohibition on cruel and unusual punishment. They have resulted in expansion of bed space and mandatory releases in a number of states. More recently, a number of states have taken the initiative to use a new model. This approach, known as justice reinvestment, involves the use of outside experts to conduct comprehensive analyses of the factors that drive overcrowding in a particular state. They then develop a set of options for that state to reduce prison populations, and the savings are reinvested in programs that contribute to public safety. Justice reinvestment is proving effective in a growing number of states, including my own, across the country. In response to questions about the shackling of pregnant women, state correctional systems are focusing on statutes and policies that improve the protocols for the treatment of women in detention during labor and delivery. 19 states, including Rhode Island, have enacted statutes restricting and the shackling of pregnant inmates, and legislation is under consideration elsewhere. I now turn the floor over to my colleague, Jim Hood, Attorney General for the state of Mississippi.
Good afternoon, Mr. Chairperson, members of the Distinguished Committee. My name is Jim Hood. I'm the Attorney General of the state of Mississippi. I'm finishing my third term in that capacity. It's an honor to be here before you today. As you might tell, I speak a little bit different than my colleagues here on the panel. I'm from the southern United States, and I hope the interpreter doesn't need an interpreter to understand my remarks. I am the president of the National Association of Attorneys General this year, and I don't speak on their behalf. I would like to address a few questions that were raised earlier. Mr. Modvick, you raised a question about training and use of force. As Attorney General, our office is responsible for training state and county and municipal law enforcement. I know many big countries, Denmark may, but I think have a state capacity. But in the United States, we have completely separate system, a judicial system, state prosecutors, and we prosecute most of the cases, criminal cases. So in our system, we have extra protections. The United States Constitution provides the floor. The states can provide more rights, and in some cases, some do. In some cases, the states violate the floor, and the federal Constitution and the federal courts are the backstop for our actions. But in the training capacity that we do in most local law enforcement officers as to the use of force, they're all trained when they go to the academy. In most instances, they're trained annually as to the use of force. Most law enforcement agencies actually have a written policy on use of force. I know you can go online. Chicago, for example, has these use of force policies online. Mr. Modvick, Mr. Gaye, and Ms. Belmer asked about training and the use of tasers. Most agencies, they train annually. The officers all have to experience being tased. There's a Taser International is a company that provides some guidance and a lot of training that's available. So for liability purposes, they are active in the training area of local law enforcement and how to use the taser. Chicago, for example, Ms. Belmer, you were asking about Chicago officers' use of tasers. There's an actual website where they have their policies and how the proper use of tasers, and that's at directives.chicagopolice.org. So there are those mechanisms in place and written policies. The last issue that I would like to address deals with interrogation and reporting of abuses. I was a district attorney. I tried cases. I was served 2 terms, tried about 100 jury trials, and I directed law enforcement in my 7-county area as to what type of interrogations they should do. I required in most instances a video of interrogation so that we knew what was asked and how the suspect was treated. Some instances they didn't have that capability. We would do audio of any statements that were given by a defendant in a custodial interrogation context. I found that law enforcement officers in my 25 years as a prosecutor actually want to do the right thing. They want to be trained properly so that they aren't embarrassed in court. They don't want their evidence thrown out because they didn't provide the proper instructions to a defendant. And they want to try to do the right thing, and they have a duty to learn to do it the right way. They usually do that, but in instances where they don't, where they violate someone's constitutional rights, then there's a backstop. There's federal court, and they might be sued under Section 42 U.S.C. 1983. That's where in federal court you can sue someone. They can also be sued in state court, and lastly, they can be prosecuted criminally in the federal court system or in the state system by abuse of a person in custody. They have a duty to report any type of abuses during interrogations to their superiors, or they are subject to losing their job. I now turn this over to Nader Baruch, the Department of Homeland Security. Thank you.
Good afternoon. Mr. Chairperson and distinguished committee members, on behalf of the United States Department of Homeland Security, or DHS, I welcome the opportunity to participate in today's presentation. I am Nader Baruch, the Associate General Counsel for Immigration at DHS. My department houses most of the government agencies involved in the U.S. immigration system, including the Immigration and Customs and Border Protection, which I'll refer to as CBP, whose mission it is for border management and control, U.S. Immigration and Customs Enforcement, or ICE, which I'll refer to as ICE, whose primary mission is to promote homeland security and public safety through the criminal and civil enforcement of federal laws governing border control, customs, trade, and immigration, and also U.S. Citizenship and Immigration Services, which I'll refer to as USCIS, which oversees lawful immigration into the United States. In carrying out our diverse missions, including protecting human rights, securing our border, and facilitating lawful trade and immigration, my office ensures that the rule of law remains at the core of our mission. Mr. Chairperson and Mr. Motovic, you generally asked about our immigration detention system. The U.S. strives to ensure that undocumented migrants are treated humanely and in a manner consistent with the U.S. Constitution and laws and applicable international obligations. DHS personnel exercise prosecutorial discretion on a daily basis, which ensures that an individualized determination based on that person's circumstances is taken into account. Prosecutorial discretion is exercised in a broad array of enforcement actions. ICE implemented guidance on prosecutorial discretion in a memo dated June 2011. However, Congress has passed laws designating certain criminal or terrorist activities as sufficiently serious to warrant mandatory detention pending a removal decision by an immigration judge. But Congress has also given immigration agencies discretion to release most other removable persons. There are protections when an individual is placed into immigration removal processes. These include advising the individual of their right to a lawyer and their right to appeal decisions. The United States is committed to a safe, humane, and efficient immigration enforcement system, including substantial use of alternatives to detention programs. This program has had more enrollees at this time than it has ever had before. Additionally, the Department of Homeland Security and Justice are working to ensure that removal hearings are completed more efficiently, thus reducing the time period in which individuals may be subject to civil detention. Mr. Motovic, you asked about identifying asylum seekers and training for officers in this area. The U.S. ensures that it provides mechanisms for individuals to raise protection claims. As one example, if upon arrival an individual at a port of entry manifests or expresses a fear of return to his or her home country or an intention to apply for asylum, the case is referred to an asylum officer for screening, and as appropriate, the individual's case may be referred to an immigration judge. Additionally, individuals in the U.S. can raise asylum and protection claims before USCIS or before an immigration judge. As to training, in line with their scope of responsibility, appropriate DHS officers undergo training related to protection claims. All new CBP Border Patrol agents and CBP officers receive training at the Federal Law Enforcement Training Center on processing and screening of individuals for possible victimization. Additionally, they receive training regarding the impact and key indicators of human trafficking and appropriate treatment of minors. ICE enforcement and removal operation officers receive generalized asylum training as well. Additionally, there are hundreds of trained professional asylum officers deployed throughout the United States by USCIS to conduct protection interviews, and the immigration judges in the Department of Justice have substantial training and expertise on asylum claims. Mr. Chairperson and Mr. Milotovic and Ms. Prada-Mala, you asked about conditions in detention, including health care. The U.S. works hard to ensure that migrants are treated humanely and in a manner consistent with U.S. values and with the U.S. Constitution and laws and applicable international obligations. These obligations are incorporated into concrete detention standards to which all facilities that hold civil immigration detainees are held accountable. As to health care, I would like to turn to those questions. DHS has significantly improved the health care services for all persons in its custody, including women. The ICE Health Care Service Corps provides direct health care to approximately 15,000 detainees in ICE custody. They also oversee the medical care provided to all other detainees and ensure that care provided accords with applicable standards. You also specifically asked about women in detention. ICE's most recent set of national detention standards incorporates a new standard focused exclusively on the medical care provided to female detainees. This standard establishes uniform minimum requirements for the adequate provision of women's health care, including gynecological and obstetrical care, and amongst other things, female detainees are entitled under this standard to routine age-appropriate medical assessment, prevention services, birth control, and pregnancy services. DHS has also adopted policies prohibiting the use of restraints on pregnant women and women in post-delivery recuperation absent truly extraordinary circumstances that render restraints absolutely necessary. And there is an outright prohibition on the use of restraints on women in active labor or delivery. You also specifically asked about how we enforce standards in private detention facilities. I'd like to emphasize that publicly and privately owned or operated detention facilities are held to the same detention standards. The Custody Management Division of ICE ensures that all ICE detention facilities, including contract facilities run by private companies, comply with ICE's national detention standards. In order to ensure that these standards are met, ICE regularly inspects these facilities. Mr. Chairperson, Ms. Pradamala, you asked about the Prison Rape Elimination Act, which I'll refer to as PREA, and how we address claims of sexual assault in immigration detention. The Department of Justice and the Department of DHS's Prison Rape Elimination Act regulations contained extensive requirements that all allegations of sexual abuse in facilities are to be thoroughly investigated and referred to the proper authorities where appropriate, and that agencies follow a uniformed evidence protocol. These regulations require that there must be multiple internal and external mechanisms to report sexual abuse, and staff are required to report any knowledge, suspicion, or information regarding an incident of sexual abuse or sexual harassment. They also require that the relevant standards it sets forth be incorporated into any new contracts, contract renewals, or substantive contract modifications with detention facilities. As part of its ongoing effort to promote PREA implementation, ICE is currently updating its 2011 detention standards to include the standards set forth in the DHS PREA regulations and plans to pursue contract modifications for the detention facilities with an average daily population of over 150 in the near term. Additionally, in May of 2014, ICE issued a revised directive on sexual abuse and assault prevention and intervention, which strengthens pre-existing agency-wide policy and procedures for responding to incidents or allegations of sexual abuse or assault of individuals in ICE's custody. ICE detainees may report a sexual abuse or assault incident to any of several different entities, such as the DHS Office of the Inspector General, the ICE Office of Professional Responsibility, the ICE Detention Reporting and Information Line, and DHS's Office for Civil Rights and Civil Liberties. ICE's policy requires that each such allegation be promptly, thoroughly, and objectively investigated by qualified investigators. ICE detention standards also require that confirmed perpetrators be disciplined accordingly. Mr. Chairperson and Mr. Motovic, you asked about how we address complaints of abuse in immigration detention. Federal and state law establish standards of care to which all migrants detained in the U.S. are entitled, including those held by ICE. The ICE Office of Detention Oversight conducts periodic compliance inspections at selected facilities where detainees are housed for periods in excess of 72 hours, including facilities where allegation of detainee mistreatment have been reported. Since September 2012, ICE has operated a detention reporting and information line, which is available in facilities that detain individuals for over 72 hours, and serves as an additional oversight mechanism for the agency. This line is directed and provides direct access to trained operators prepared to record and respond to detainee questions, concerns, and/or complaints. Additional layers of oversight are undertaken through site visits, investigation, and audits. Mr. Motovic, you specifically asked that we provide the whereabouts of our facilities. The location of all of our short-term and long-term immigration facilities are publicly available on ICE's website and CBP's website. Mr. Chairperson, you asked about racial profiling at the border. DHS takes all allegations of racial profiling by its employees or affiliates very seriously. In April 2013, which was too recent to make it into our periodic report, the Department issued a revised policy statement on non-discrimination in law enforcement and screening activities, which continues the prohibition on unlawful racial or ethnic profiling, for the first time providing department-wide policy with respect to the use of nationality in law enforcement and screening. Mr. Chairperson, you also asked about detainee representation or access to counsel. U.S. immigration law generally provides for the privilege of counsel in immigration proceedings at no expense to the government. These individuals are advised of their rights to counsel and are given a list of free and/or low-cost legal providers and the opportunity to contact an attorney or legal service provider. Mr. Chairperson and Mr. Bruni, you asked about unaccompanied children and families. As the committee is well aware, the U.S. experienced a humanitarian crisis during the spring and summer of 2014 along the southwest border of the United States as tens of thousands of unaccompanied children and families crossed the U.S. border. In the immediate crisis, we focused on getting those adults and children, many of whom had undertaken an extremely dangerous journey, into safe and secure environments for processing. Following this, the department added temporary detention space for families and plans to open a new residential center to house families in Dilley, Texas. These facilities are subject to the family residential standards. At these facilities, asylum officers and immigration courts are available to conduct credible fear and reasonable fear interviews with individuals, providing them the opportunity to put forth claims for asylum and other forms of protection. The department remains committed to safe, appropriate facilities for housing this important and vulnerable population and to ensuring appropriate consideration are given to viable claims for relief. Additionally, we are using alternative detention mechanisms for this population. At the same time, we recognize that for individuals without a viable protection claim who cross the border illegally, it is our responsibility to see them return safely to their home countries. As to unaccompanied children, we strive to hold them only for the amount of time necessary for DHS processing, arrangement of shelter placement within the Department of Health and Human Services. I thank you for your time and interest on these extremely important issues. I now would like to turn our presentation to Assistant Secretary Tom Malinowski.
Thank you so very much, Mr. Chairperson, members of the committee. Let me begin with Mr. Bruni's question about the optional protocol to the convention. And let me say here that our hesitation with respect to the convention is not that we already have a strong domestic system of oversight over our detention facilities, although we believe that we do. It's that we also see a handful of practical and legal obstacles. We've had concerns, for example, about some provisions that we feel may be problematic under our Constitution with respect to legal standards for search and seizure. And the regime established by the draft would, we feel, be somewhat difficult to implement given our federal system. And because the optional protocol prohibits reservations, we can't address these concerns in that way. We would instead need comprehensive implementing legislation to compel our states and local governments to provide information, to permit visits and private access, which would, in fact, be a fairly daunting challenge. Now, Mr. Bruni, you also asked us to elaborate on our view that torture is not an effective means of interrogation. And let me start here by stressing again what I said yesterday, that torture is and must remain absolutely prohibited under all circumstances. The United States government would oppose torture on moral grounds, on legal grounds, even if we somehow believed that it elicited useful information, period. At the same time, our experience and that of many countries shows that torture is also counterproductive. Many experts on interrogation, many survivors of torture have noted that when prisoners are subjected to pain and suffering, they often say exactly what they think their questioner wants to hear to stop the pain, whether it's true or not. In the fight against terrorism, the use of torture also makes it harder to win the trust of communities whose support we need. It fuels recruitment for our enemies, and it erodes the very rules that we rely on to protect our own military personnel if they are captured. So many of our senior military, law enforcement, intelligence officials have said over the last many years that abusive interrogation techniques were more harmful than helpful in the fight against terrorism, and that any useful information that may have been obtained this way could have been uncovered by lawful means. We expect that the Senate Intelligence Committee report on the CIA's former program and other related reports and commentaries will provide a fuller assessment of this question. You also asked about the report, when it's likely to be released, and I can tell you the executive branch is working very closely with our Senate committee to produce a declassified version with minimal redactions for public release, at which point it will be up to our Senate to choose a date. So it's up to them, but we anticipate that this will happen very shortly. In their comments, both Mr. Bruni, Mr. Doma asked the fundamental question of whether we have indeed gotten back on track and how we ensure that we stay on track. And in that same spirit, many members of the committee asked important questions about accountability for past actions as a means of ensuring that we do not return to them. And I know that our answers to that question may not yet fully satisfy everyone. But I do believe that our actions since those issues arose have been quite powerful. We've not just replaced the problematic policies, we have definitively repudiated them through the judgment of our courts, of our Congress, our President, and our people. Most important, we've had an honest public accounting. Our government's been open and truthful, even when releasing information has been painful and uncomfortable. Soon, when the Senate report is released with the very strong support of President Obama, our people and the world will know even more details. So our goal is to move forward, but we know that to avoid falling backward, we must be willing to look backward and to come to terms with what happened in the past. Moreover, rather than weakening our standards against torture and cruelty, the result of this episode in our history has actually been to strengthen them. Precisely because we experienced these problems, as I mentioned yesterday, we now arguably have more detailed and specific regulations barring abusive interrogations than any other country on earth. Some are so specific that they inevitably spark more questions, like minimum sleep requirements for detainees or rules governing how prisoners can be separated from each other on the battlefield, all of which we have been happy to try to answer today. And then there's the U.S. Army Field Manual, about which many members of the committee have asked and we've discussed today. What's most important, I think, about the Field Manual is not just that it prohibits certain unlawful techniques, it's that it provides a complete list of all the techniques that professional, experienced interrogators operating in armed conflict need to use to get truthful information. And those interrogators are forbidden from using any technique that is not listed on the positive list. I know of no other country that requires its national security and intelligence agencies to limit themselves to a specific set of interrogation methods that are publicly listed on a website. We truly believe that this is a good model. In fact, we hope the committee will promote its use elsewhere. So this process of improvement, which begins with a willingness to confront problems directly and honestly, is what distinguishes democratic countries committed to the rule of law, and it will continue in the United States. Whether it's our effort to abide by the law as we defend our country, or to protect the rights of the most vulnerable people within our society, or to respect always, here and everywhere, the right to dissent. That is the most important fact we wish to report to this committee. That is what enables us to champion the eradication of torture everywhere in the world. Mr. Chairperson, we've now finished our initial responses, and we look forward to the follow-up questions of the committee. Thank you.
Thank you. Thanks to the entire delegation and also to Ambassador and Assistant State Secretary for extensive response to the set of our questions. I guess we all agree that it's not easy within 90 minutes to cover all the issues, but again, I mean, thanks for your, I would say, very productive attempts to do so, and I guess you will still have some time at the end of the dialogue to cover the issues which still remain and also to respond to some of the new questions originating from the members. Now, I have to provide the floor to two rapporteurs, Monsieur Bruni and Mr. Modvik. Somehow I can try to provide 15 minutes to each of you. And then I guess the rest of the members, we will still benefit from our two recused members and try to get some time. So let me ask from the outset, who of the members wishes to take the floor after rapporteurs? Okay, everyone, including me. Yeah, that was to be expected. So, okay. Monsieur Bruni, the floor is yours.
Thank you, Chair. Well, I must just make a short introduction, and since I have 15 minutes, I have to choose some selected items because it is not sufficient to cover all the replies and further questions that I could have or comments. So, but I will start immediately with concrete questions. Now, the first one is about prolonged mental harm. We knew that this was a condition for the ratification of understanding, but it was meant to provide the requisite clarity. But I don't find any clarity. I'm sorry to answer so straight, because I mean, in law, you have to define certain concepts, and prolonged to me doesn't mean much. Prolonged, as I said, could be 1 day, 1 month, 1 year, 10 years. So, I mean, this has to be clarified. It's not clear at all what is prolonged mental harm. If it is possible to clarify, thanks. But I mean, I must somehow reiterate my impression that there is no clarity. Now, as regard the geographic applicability of the convention, now I was pleased to note that, I hope I understood correctly, so the applicability is to any place in the world under the jurisdiction of the government for its officials. And the Guantanamo Bay and the aircraft and ships are a sort of example of that somehow global applicability of the convention, or they are the applicability is limited to those places. I would like to have a clarification. I understood the first version, but I would like to have a confirmation of this. Now, about Guantanamo. There are, of course, I thank the delegation for the very comprehensive information given on all subjects. So, perhaps I made too many questions, so this is what I have in return. But now, on the 148 individuals of Guantanamo under law of war authority. Now, there are different categories, and there is the category of 36 detainees are designated for continued law of war detention and will be periodically reviewed. Does I understand correctly that these are suspects without formal charge? And if this is the case, why they are still kept in prison without any charge after so many years? Then I continue just choosing some important issues, but a bit at random. Now there was a question, of the 4 hours sleep. Okay. Now 4 hours sleep is indicated by, I knew about it, is a minimum standard. Okay. But a minimum standard means that it can be applied. It is legal to have 4 hours of sleep for a person under interrogation. It's permissible. So it can be done for 30 days and more, because this treatment can be renewed. So the question remains the same. 4 hours of sleep equal deprivation of sleep. So my suggestion is that this Annex M of the military interrogation manual be simply deleted from the manual. Okay? This is my suggestion. So then we heard later that this manual is a sort of good model for other countries. Perhaps, I don't know, I leave it to the specialists. But provided that this Annex M is deleted, then we can discuss about it. Then, enteral feeding. I like this expression. I knew the expression forced feeding, but enteral feeding, sometimes there are terms, nice terms to indicate somehow embarrassing practices. Now, it is said that there was no harm to the prisoners. It was for their health. Okay, I'm not going to prolong this debate. But why not to disclose as evidence that it was a sort of humanitarian intervention? Why not to disclose the evidence? Why not to disclose the video? There is nothing to hide. I don't see why, otherwise one gets suspicious. If you don't disclose the videos, you say, maybe something was wrong there. But anyway, I thank the Ambassador of the United States for mentioning the visit of the special rapporteurs. But actually, we know that the special rapporteur can operate in an efficient way only by interviewing person. So I wonder where the security problem is. The Well, I'm not going to elaborate more on that. Now, the question of registrations. Well, we were guaranteed that registration, the registration of detainees. We were guaranteed that the registration is done in times of war, in times of peace. Registration is done. But, I mean, my point was about the wording of your report. That is to say, your report states clearly that registration is not a requirement of the convention. And my position, but I'm not the only one, my colleague's position, I hope, is that registration is the first step to prevent torture, and it is contained in Article 2 of the Convention. So this was the point that made me raise certain questions. The high-value detainee interrogation group, but I appreciate the information received, but which does not go very far, because again there is a statement. You name this group, you say that it has special interrogation techniques. I know this was in the report, this is in many documents, and finally you say, but it's perfectly in conformity with the convention, with the humanitarian law, and yes, but there is a blank. What are these methods that are in conformity? You give me statement, not explanation, not evidence, nothing. Now, on the question then on the applicability of the Prison Rape Elimination Act, here I must say I'm satisfied with the information because I understand, and I hope I'm correct, that this act applies to federal, state, and local prison establishment. We were informed about the contrary. That is to say, it is not applicable to state prisons. But if you stated clear that it is applicable to state prisons, so I hope that this corresponds to reality. Now, there are so many. I'm glad also that the delegation acknowledged that there are many, at least I would call them recourse, against the overcrowding of prisons and which are contrary to the 8th amendment to the Constitution. Now, the question of solitary confinement. Now, if I understood correctly, there are only 400 persons in solitary confinement in the maximum security prisons. But I don't know about the quantity. One could get different information. But I'm talking, my worry is about the quality. Because a person which is kept in the same cell for at least 22 hours a day, in a long run, becomes insane. And if you have persons in solitary confinement for over 30 days, means that you are directed them towards insanity. And this is a fact. So there, again, I have my doubts on this practice. Then, of course, there is the question of unaccompanied children and their families. You say that there are measures to improve their recourse, but apparently many of them are expelled immediately. and we talk also 95% of family of an accompanied children from Mexico are returned to the United States without a hearing. I don't know if this corresponds to the reality, but I must underline that often these accompanied minors and their family are trying to avoid, violence in their countries, and so, hearings are really necessary in most of the cases. Now, about the optional protocol and Article 22 of the Convention, I thank for the explanation. At least it was elaborated, this explanation. I can understand the legal difficulties that may occur, but where I quoted your report, in the report it states, no, we do not have the intention to accept the protocol or Article 22 because we have a system of recourse at national level which is 100% good. Well, this is now maybe a good explanation. I understand better the explanations given today, but still, at least at the political level, I think that the question should remain, whether would not be a sort of good challenge to accept certain international mechanisms which allow, on one hand, the optional protocol, the visit to places of detention, so to have a sort of, checking, as I was saying before, of your recourse procedure, of your prison system.
I'm sorry, time has run out. So.
Okay. And I finished the sentence. And then also, especially for individual communications procedure, because you allow the individuals, your citizens, to appeal to an international organ which does not establish, it's not a sort of super judgment, but is simply, establishing whether a certain treaty has been respected or not, which gives a view on that. Now, I'll stop here. Time is limited. Sorry for, I had many other comments to make, but we'll see if we have time later. Thank you.
Thank you, Mr. Bruni, and Mr. Modvik. The floor is yours.
Thank you very much, Chair, and thank you very much to the delegation for its very comprehensive replies and all the work that has obviously been put into answering the questions of the committee. The committee would like to appreciate the recognition that you made in your opening statements that torture has been committed, and also the position that reparation must now be implemented. And we appreciate the spirit of collaborating with the committee about implementing this project. Harold Koh, former legal advisor to the U.S. State Department, recently wrote an open letter to President Obama. He addressed the issue of applicability of the Convention Against Torture. He wrote, inter alia, that the committee here is going to put a question to the delegation, namely, will the United States abide by the Universal Treaty ban on torture and cruel treatment in armed conflict or beyond United States borders, including Bagram and Guantanamo? I would like to make Mr. Koh's question mine and ask this question to the delegation, and hope that you will be able to present a clear and unconditional yes to this question. In this connection, I would like to ask if the State Party will consider withdrawing its reservations to Article 16 of the Convention. Regarding the applicability of the Convention under times at war, I understand the answer anomalous to provide detainees with the right to claim for monetary compensation for alleged unlawful conduct, as if it's the position of the state party that Article 14 of the Convention is not applicable because the laws of war supersedes the Convention when it comes to the right to rehabilitation. That is, we consider them as enemies, not as victims. As to the transferring Guantanamo detainees, no Yemeni detainee has yet been released since 2010. Does the state party intend to ensure repatriation of the 58 Yemeni detainees that have been cleared for release in the near future? As to the questions about the field manual, Mr. Bruni's question was replied to, but not mine. My question related to the field expedient separation, which involves a deprivation of sensory inputs that has scientifically been demonstrated to provoke psychotic conditions. So I did not get any response to the considerations of whether this might involve ill treatment. I didn't either get an answer to my question about whether CIA agents were included in the training mentioned for law enforcement and whether also the CIA are limited to the interrogation methods in the field manual. I would appreciate a clarification here. As for the Durham investigation or preliminary investigation, in most cases found that there was not sufficient evidence. Well, you might think that you don't find what you're not looking for, because there were between 100 and 130 detainees in CIA custody as part of the RDI program. That's not that many. Was any of them interviewed? As for the force feeding, my question was relating to an assessment of the ethical aspects, not the legal aspects of it. The reply I got was that this is not illegal. My question was, but is it ethical? Another question that was not answered was my question of whether cases of sexual abuse by military could be brought to civil courts. Would appreciate a reply to that. As for the isolation or solitary confinement questions, one of my questions was if you would please provide the number of suicides, attempted suicide, and other self-harm during the reporting period among detainees and prisoners held in solitary confinement, as to evaluate the impact of this confinement. Concerning the Prisons Litigation Reform Act, the concern is that the procedural requirements for the internal grievance mechanisms are so complicated that it seriously discourages or even prevents prisoners from filing lawsuits. So my question was, what was the number of prisoners who filed claims in civil courts for redress for acts of torture or treatment that have been dismissed because of lack of compliance with the procedural requirement? As for the militarization of the police, there are disturbing patterns of excessive force on part of police officers, especially towards African Americans and other persons of color, which seem to demonstrate that the current mechanisms of accountability are insufficient. We have information that many federal investigations against police officers for unlawful and excessive use of force were closed without criminal charges because they did not present sufficient evidence of willful misconduct to give rise to a federal criminal prosecution for the police officers involved. So the question is, how is the federal government going to ensure effective accountability and hold officers accountable for instance, fatal police shootings, like in the case of Mike Brown, whose parents are present here, consistent with the obligations under the Convention? What steps will the state party take to ensure that there's appropriate oversight over the 1033 program, the Homeland Security Grant Program, and the Edward Byrne Memorial Justice Assistance Grant Program in order to ensure that the militarization of state and local law enforcement ceases? In continuation of this question, I would appreciate to hear how State Party ensures accountability for police sexual abuse. As for the question of medical services and access to medical care in the prisons, the principle of equivalence of care, of course, applies, and I appreciate the replies here that the quality of the medical service in prisons match the quality of the medical service outside. However, there's also the question of access. Independence of the medical profession is not applicable for medical doctors employed by the law enforcement. And this means that prisoners here are in fact deprived of the right to a doctor of their own choice. And as I mentioned, they risk a mixture between security and health concerns. As for the questions on asylum and the procedure, I appreciate the extensive replies. However, I think it was a little bit beyond the point of my question. My question was, how are victims of torture identified among asylum seekers? And I didn't hear a specific reply to this. And I would like, in this connection, if you could please provide the committee with the training material and the procedures that apply in exactly this point, namely how are victims of torture among asylum seekers identified. I would appreciate if the submission of the training material and procedures would also include how protection of vulnerable groups like minors and people with mental health disorders are complied with. These were my questions in this round. Thank you.
Okay, thank you, Mr. Modvik. This provides me now the opportunity to grant 3 minutes to each of the members, and the first one on the list is Monsieur Doma. The floor is yours, Mr. Doma.
Chair, thank you very much. Subject to whatever the two rapporteurs have commented, I appreciate the candid nature of the admission by U.S., admission without torture, of, I must say, zero tolerance to torture. That is heartening. Heartening not only for itself, but also for our work, the international community, including each and every state member of the convention. U.S. would regain its blighted image if it began a process of reconstruction and restitution of the dignities of each of those subjected to torture. And we are not talking only of the victims of Guantanamo Bay. We are talking of the others, as a result of police brutality, your systems, against cruel and degrading treatment. How would U.S. try to give its citizens reparation to the victims? There are so many others: church, priests, LGBTs, racially motivated arrests, police abuse. How would you undertake due inquiry in all cases without creating pockets of public accountability or public scrutiny? Reparation, we've heard, is available, but let us understand this: injunction and damages are not enough. When a human being loses his human dignity, there is more we have got to do to restore his human dignity than just money, because human being is not a vehicle which can be repaired by money. So compensation in the word of, within the meaning of the convention, goes well beyond just monetary compensation. There are so many systems available through the systems used by other countries who might wish to learn from this. Now, we need a reappraisal for whatever has happened. Vestiges of past systems, methods may still exist. We have got to ensure that they are eliminated. With respect to historical injustices, recent injustices, and continuing injustices, the question I have often asked myself, where were the professionals when all this thing was happening? Did they come up and advise the officials that, things were going wrong and you have got to come back? I'm thinking, for example, of the American Bar Association. Thank you. Thank you, Chair.
Thank you. Now I have to pass the floor to Mr. Zank. Mr. Zank, the floor is yours.
Thank you, Mr. Vice Chair. And first, I would like to thank the U.S. delegation for the feedbacks, and in particular, the information provided by Heiger and David from the Ministry of Justice regarding the training. And I have a couple of questions. First, according to UC Berkeley Law School's research, there are cumulative impact on the families of the detainees of Guantanamo. And to cut it short, is first impact on family members, wives and kids who were in poor health and who had debt and who dropped out from schools, and economic hardships, plus psychological and physical harm of indefinite detention of the detainees. I wonder whether the delegation can provide some information on this in this regard. Second question is regarding this abuse of force and the torture given by the CPD. And according to the NGO's report, for instance, from 2009 to 2013, although the black people comprised only 32.3% of Chicago's overall population, 75% of the police shooting victims were black. I just wonder whether the delegation could comment on the or share information on the investigations or monitoring systems that are in place to review the CPD's patterns and the practice of the alleged torture. And the last one is regarding this report by the NGOs on the abuse of children by priests. According to the report, there's in Diocese of Minneapolis, St. Paul, a lawyer resigned, but later reported that the church officials made special payments to abuse the priests, namely to ask them to move, to leave the place instead of bringing them to justice. And also in 2012, Bishop Robert Finn of Kansas City, who was convicted of failing to report suspected child abuse by Father Shin Radigan, and who is now serving a 50-year sentence for child pornography. Well, this Robert Finn, remains in his post today, while he was also convicted. So, thank you very much. If you can provide also for the...
Thank you, Mr. Zank. Now I pass the floor to Ms. Prada Mala.
Thank you, Chair, and thank you for responses by the delegates from USA. It wasn't easy, but you responded so well in a transparent way. I have a very specific question today. Violence against women amounts severe pain, suffering, it amounts torture, it is cruel, inhuman treatment. And my question to delegates is what mechanisms are in place